Hello, and welcome to Legally Speaking, a podcast series that aims to make the law and legal issues that affect your everyday life more accessible and maybe a little less scary. As this series is brought to you by Ison Harrison Solicitors, the Yorkshire law firm, in this episode I'm joined by Amy Law, clinical negligence solicitor for Ison Harrison. Good to have you with us, Amy.
Hi, thanks for having me.
With concerns being voiced about missed appointments for serious conditions and hospital appointment backlogs as a result of the pandemic in the news recently, it's probably timely that the subject area for this episode is around oncology and cancer claims. Amy, what would be classed as a cancer claim? And once you're sure that there's a case to be made, how long would I have to make a claim?
Well, a cancer claim is a type of clinical negligence claim. Clinical negligence is essentially a claim for compensation for an injury that's been caused as a result of negligence. So in relation to cancer, it's usually surrounding a delay in diagnosis or a misdiagnosis of cancer. I've worked on cases where, they've done, a patient's recently had a scan which has shown that there's sort of cancerous tumours in, say, the abdomen or the chest. And then when the hospital have looked back at earlier scans a couple of years prior to that, it's obvious that it was present at that time and it should have been diagnosed. And really it's about what difference that delay in diagnosis has made to you as a patient. So in terms of pursuing a claim, we do clinical negligence claim for all sorts of things, not just for oncology, but in just talking about this today. There are certain legal tests that we need to meet as to pursue a claim. Now, there's no doubt that a medical practitioner owes a patient a duty of care. That is just a given. But to establish negligence, we have to prove that there was a breach in the duty of care. So we're not looking for a golden standard of care. We're not, not the best possible care out there, but there is a reasonable standard of care, and it's whether or not the care provided to you fell below that reasonable standard.
Yeah, there's got to be some kind of minimum level you would expect for it
Exactly.
to be, basic.
Well, that's the first test. I mean, if we can establish that there was a breach of duty, the next sort of hurdle to get over to win is to prove causation, which is what difference did that make? So I have had cases where there's been an 11-month delay in diagnosis of a tumour in the throat. And when we got independent expert evidence to see what difference that had made, it actually made no difference at all. It's not always just because it's been missed or, there's been a delay, then it doesn't necessarily mean that there is a claim. His treatment would have always been the same and the outcome would have always been the same. On the flip side, I've had a couple of year delay in diagnosis of lung cancer, and had it been diagnosed earlier, it would have been curative, and by the time it was actually diagnosed, it was terminal prognosis, and it's the unthinkable. So the second part of the question, there is 3 years to pursue a claim. So that's 3 years from the date of negligence or your date of knowledge of negligence. So if the negligence happened 2 years but you've only found out about it now, you can't be expected to bring a claim then. So that it is a very, very strict rule. And unfortunately, if a patient were to die prior to the estate bringing a claim or during a claim, the clock starts again from 3 years from the date of death.
Right, so at least, as strict and tight as it is, there are other options for you. Obviously, you just used an example there where there was a 2-year lag before diagnosis. Yeah. So, it's leaving it quite tight to bring any form of claim. Yeah. Let's take a scenario then. My loved one has died as a result of cancer, sadly, but I think it was diagnosed too late. Is it back to this idea that I then still have a 3-year period, or is there a different effect once, sadly, they've already passed?
Yeah, even if it's your date of knowledge and you've had thoughts after they've died, it is still 3 years from the date of death. And you're a layperson, we're a layperson, we're not medical experts, so we say come to us as soon as we can, because sometimes actually making a complaint to the hospital or the GP or whoever is involved in the potential breach, doing that bit of investigation can either give you a bit of peace of mind or closure as a family, or it might raise further concerns, and you can come to us at that stage as well.
So what damages can you actually recover or look to recover as a result?
Well, where do I start? There's a few different sections that we'd look at. So firstly, we look at the pain and suffering and loss of amenity that you have suffered. Again, this works in two different ways, really. It depends on whether the patient is still with us or whether they have died, and what kind of damages you can claim for is different in different kinds of claims. So, yeah, we do look at the pain and suffering that's been experienced, and that's one element to it. The other elements are any special damages, so any past financial loss you or your family have suffered as a result of the negligence, and also any future financial loss. If you're needing care for the rest of your life, 24-hour care or just any care that you wouldn't have had to pay for otherwise, then that's something we'd look to include. If someone's lost a loved one, the estate can look to claim for sort of loss of services. So as an example, we had a family who'd lost the father, and there were 4 children and grown-up children, but he did all the DIY, everything with the cars, he did absolutely everything for the kids, and they were the person that he turned to. And it's that kind of thing we can look to claim for. Loss of financial dependency for a wife that's lost a loved one that maybe relies on the pension. So there are a lot of different elements to it, but sometimes it's things that you wouldn't even think about, but it does add up. What
kind of thing have you found has surprised people that will be covered by it?
Mainly loss of services dependency, is it that example I've used, because when you put that to people, they just sort of brush it off. Well, he just did it. He just would have always done that. But the point, he just trimmed the hedge, but the hedge took 2 days to trim because it was huge, and you're now going to have to pay a gardener for that, and that adds up every year. And things they would do around the house, things like that. It's stuff that you wouldn't think about that makes a big difference.
Yeah, as you say, if you replace the fact that they were a parent with people that would come and supply those kind of services, it's a very different perspective. So
that's it. You can also claim for a statutory bereavement award, which is a set amount that a surviving spouse would be entitled to, for the loss of that loved one as well.
So, Amy, thank you. That very much covers off kind of reparation as the result of a bereavement. Palliative care, though, if my loved one or I've received care from my local hospice, is there any way that their costs can be recovered as part of a claim? Kind of give something back to them?
Yeah, absolutely. We have had this happen on a couple of cases where, as you say, a loved one has spent their final weeks, months in a hospice, and the family want to give something back. Now, the hospices generally do get some NHS funding, but a lot of it can be sort of charitable donations. So you can seek to recover as part of the claim some of the costs incurred by the hospice that wasn't funded by the NHS, because it's generally the NHS that are paying the damages. But yeah, we've had it on a case of a young lady, a young woman in her 40s who died of cervical cancer, and the family, it was really important to the family to give back because the hospice were just incredible. And we managed to raise a cheque for that amount, and the family could then take it to the hospice and hand it over in sort of a presentation, which a lot of families find really important, and it's a nice part of my job to be able to help with that.
It's a really nice thing to do, and like you say, be able to facilitate on their behalf. Taking me as an example, potentially, I've been told that my cancer's incurable. So I believe it's at stage 4 and beyond. Yes. Yeah. What can I claim for to look after my family once I've gone? Because that's really going to be my key concern here.
Yes. We have this a lot where, people are sort of stage 4, end of life, and they use what energy they have to be contacting us because they want to look after their family, and that's the crucial point. Unfortunately, it does happen where clients die in the process of a claim, but then the family or the estate can continue with that. Again, it's the same damages. They can look to recover any loss of financial dependency, services dependency. But we try to. I have a client at the moment who just doesn't have the energy to be involved in the claim, but wants to crack on with it. Yeah, so we are happy to deal with the family as well if. To take instructions if that's what the client wants.
Wills, always a touchy subject for families, especially at a time like this, potentially. And I don't mean within the family, but do I need to be named in somebody's will that's passed to be able to bring a claim for my loved one on their behalf? And actually, do I need to be the executor rather than a beneficiary in order to do that?
Yes, in short. Again, this is something we would always raise with clients at the beginning of a claim, especially of this nature, whether the person does have a will in place. If so, who are the executors? So the executors are the people that have the right to bring the claim on behalf of the estate. Just because you're married doesn't actually give you that right. If you didn't have a will, there is an option to get a grant of probate that appoints you as the personal representative, and you then have a right, but that just causes further delays. So we try and get these things in place before the inevitable, and so that the family are set to go, really, if we need to carry on. The beneficiaries are the people who would benefit from the will, and in this case, from the damages. The damages will be split dependent on what the will says.
I mentioned it as someone who's been diagnosed with cancer has been delayed as the result of COVID. Is that something that I can make a claim for if it's had an impact?
Absolutely. We are getting a lot of these calls, unfortunately. It's having a massive impact on how quickly things are getting dealt with, appointments are getting pushed back. I wouldn't say you've definitely got a claim. Again, we just take each case on a case-by-case basis, but absolutely, if COVID has caused delays, unreasonable, negligent delays, then there is potentially a claim then, yes, but always inquire, and again, case-by-case basis.
Thank you, Amy. That's an excellent overview for anybody that finds themselves either personally or their family in that situation at this current moment in time, especially, that last question. And based on how relevant it is, do get in touch with the clinical negligence team at Ison Harrison, which of course includes Amy. You'll find them at isonharrison.co.uk.